about the history a little bit of the NIL issue, just to put it in context of what this bill does. I'll talk about what the bill does, and then I'll kind of talk about the partners that have worked on this legislation today. So a flurry of states moved to adopt NIL bills shortly after we did, because it's what colleges have to do now to stay competitive. And eventually, in June 2021, the issue went to the Supreme Court with the case NCAA versus Alston. The court in that case found that student athletes could receive education-related payments, which limited the NCAA's ability to restrict athlete compensation. With new state laws taking off across the country and support for NIL at an all-time high, the NCAA introduced a policy in July 2021 allowing athletes to profit from their name, image, and likeness rights. This was a historic shift, giving athletes the freedom to sign endorsement deals, grow their brands, and earn income without breaking NCAA rules. However, there were various restrictions and conditions around those rights, which had to be compliant with NCAA policy. Fast forward to 2024, a landmark case in college athletics, the House versus NCAA case brought by college athletes, argued that the NCAA's rules unfairly restricted student athletes' ability to profit from their name, image, and likeness. The plaintiffs argued that the NCAA's restrictions on NIL payments and control of broadcast TV markets, primarily during March Madness, prevented student athletes from realizing their true market value. The suit was granted a class action certification, and the NCAA agreed to a preliminary settlement of $3 billion under a revenue-sharing model to allow member institutions to distribute funds to current and former Division I players for its prior use of their NIL rights dating back to 2016. However, the settlement includes a number of restrictions and conditions that would unnecessarily limit athletes' rights to NIL participation and compensation, and could lead to violation of our own statute if Nebraska were to opt in, because our statute currently prohibits universities from directly paying NIL compensation to athletes. A ruling could come sometime this year, but the settlement has opened the floodgates to universities and states rushing to compete to recruit the top athletes by reforming their laws and offering direct compensation so they can get the settlement funds. It's my understanding also that even if a ruling comes this year, the expectation is that there will be appeals or subsequent denials in a complex legal battle that could take years, leaving states without secure laws flat-footed. Between July and September 2024, the states of Georgia, Illinois, and Virginia adopted NIL laws that explicitly allow their college programs to directly enter NIL deals with and pay NIL compensation to their college athletes like this bill. California has clarified that their NIL law also permits this. In addition, laws in at least 17 other states prohibit universities from complying with the House versus NCAA settlement that seeks to allow the NCAA and conferences to impose NIL restrictions on or punish their universities and athletes. Therefore, Nebraska must be vigilant in ensuring our NIL law provides college athlete freedoms that are no less than those of college athletes in other states. States that do not allow their college athletes to enter into NIL deals and receive NIL compensation from their athletic programs will be at a significant disadvantage in recruiting and retaining talented college athletes. Universities need states to update their NIL laws to compete and treat their athletes fairly, as well as to ensure their own rights and responsibilities are protected from any liability or potential punishments from noncompliance with conference policies. I'm grateful to the National College Players Association for keeping me informed about this and working with me and my office on the language to make sure it models best practices for student athletes in universities in other states. Also grateful to University of Nebraska for being a constant partner in contact about this bill. The language reforms our existing NIL law to keep us ahead of an ever-evolving landscape to provide certainty that regardless of what happens with this or any other future settlement or case, Nebraska's players and universities will be ahead of the game, competitive, and have the freedoms to recruit and participate in NIL activities protected by our state law. Specifically, this bill adopts standards for athlete agents in the absence of college athlete agent certification body, protects student rights to NIL compensation for First Amendment protected speech, requires written agreements and specifies terms and conditions that must be included in those agreements so students know exactly what they're signing up for and have supporting documentation in the case of a dispute, allows universities to provide education around these matters to students, and gives institutions the protection from investigation or punishment for noncompliance with conference restrictions, opens up direct university pay to players rather than removes the current restriction from that in our statute, but it doesn't require the university to do so. It just says that they can if they want to. And it prohibits the NCAA and other conferences from directly imposing NIL restrictions on or punishing athletes or universities for noncompliance with their policies, and says they cannot investigate or punish institutions or athletes for any activities authorized by state law. I'm grateful for the productive conversations with our University of Nebraska representatives and our advocates with the National College Players Association. We had a great meeting this weekend, and they've been great partners in this effort. And I think we're all on the same page of sharing the goals of, one, wanting to make sure we're both protecting our student athletes from financial predation or manipulation in making these deals while maximizing their opportunities, and two, giving our universities broad latitude to educate, recruit, retain, and compensate their athletes as they see fit, while ensuring they don't risk sanctions for noncompliance with conference rules or disadvantages for recruiting compared to other states. We have such a strong and proud tradition of Husker athletics in our state. LB370 is a necessary step to keep that competitive edge. I understand that the university wants to make sure they are in compliance with state law and are still reviewing the finer details of the bill, and they've opted not to take any position for today's hearing and are going to continue to monitor the situation for updates. I appreciate their partnership, and they have my commitment and promise to continue to wrap them into any developments on this bill, and also toward our shared goal of increasing talent attraction and retention to the university. As NIL compensation grows and interest in this space has exploded, many universities have reversed course from wanting more restrictions to wanting more freedoms to be competitive. For example, some universities in other states have begun offering NIL advances to recruits. We're seeing many other states leap ahead to make sure their laws are ahead of the game on this, and I do not want Nebraska to be left behind. Thank you, and I'm happy to take any questions.
Thank you for your testimony. Senator Raybould.
Thank you, Senator Hunt, for the history on it. It's a topic I'm completely not familiar with. But, okay, so currently, does the state of Nebraska just give the athletes educational, like, funding benefits, or do they now permit the athletes to receive compensation directly and they're not an intermediary, or how does...
Right now, the athletes don't receive compensation directly from the university, but because of the NIL bill we passed in 2020, they are allowed to enter contracts with, a restaurant or any business to basically do like an endorsement deal or something like that.
And so for recruitment purposes, can the university offer them, besides scholarship, like room and board, are there other things that they can offer?
No.
A contract?
No, but kind of the workaround that has happened is, what's this PED funded thing? It's called the 1870. Yeah, collective. There's this collective. And so donors can donate to the collective, and then the collective can give money to students. And that's not directly from the university, but, it's not part of the university, yeah.
Okay, thank you.
Senator Sorrentini.
Thank you, Senator Coe. I think in light of the upcoming House versus NCAA settlement, whenever that really is settled, these athletes might become actual employees of the university. It's not where they're at yet, but leaning towards that. My only question is, in the bill, it refers to athletes. I'm assuming that is male athletes and female athletes and transgender athletes. Is there any delineation? Athletes and athlete in this bill?
Athlete's an athlete. We don't specify gender.
So expectations that there should be some corresponding value based on the revenue for that sport for a female athlete if she plays volleyball at the University of Nebraska, which probably brings in more money than, with the exception maybe of football, they should be paid accordingly.
Well, yeah, what I joked about, not really even joking, but what I said in 2020 was, my original NIL bill, it wasn't for a football team, it was for the volleyball girls. They're the ones who are going to get these great deals because they're crushing it. And I think the intention behind NIL legislation and practices is just to allow students to participate in the market just like any other student. If I went to UNL and I was a music composition major, I could make money doing a YouTube channel and monetize my YouTube channel and say, I'm Megan, I go to University of Nebraska, here's some information about how to compose music. But if I was an athlete, I couldn't do that until we passed the NIL bill. So it's really not the university saying, here's what men are worth, here's what women are worth. It's just the market. It's whatever kind of deal they can get, and I think that's what's fair.
I think for down the road, it's important to realize this would only apply to like in Omaha and Creighton, because NIL doesn't apply to Division II schools, but I wouldn't doubt that is the next step.
Well, I disagree because of NIL legislation, students at Peru State or Chadron or like any other smaller college or university in Nebraska, they can get these sponsorships too. They can monetize their YouTube channel too. They can post a sponsored Instagram ad too. And before they were never allowed to do that.
My understanding was they couldn't get NIL money at Division II schools.
That's from the settlement,
Right.
but that's not NIL in general.
Thank you.
Thank you, Senator Sorrentino. Any other questions? Seeing none, we say to close?
Yes, thank you.
First proponent. Any proponents? First opponent. Any opponents? Senator Hunt. Okay. Let me see.
Do any of you have other questions?
Pardon? Yeah, I'm getting to neutral. I was going to read the.
Okay, sure.
Is there anyone speaking in the neutral? No. Okay. Do we have any letters? I don't think we do. Hold on. Oh, there it is. There it is. Okay. 2 proponents, 3 opponents, and 0 neutral. And Senator Rabel has one more question.
So it's kind of my favorite question today. So what are some of our other states, like what is Colorado up to? Or is everyone waiting for the court determination? Or how can we, what should we be doing to be more competitive?
I know that there are 17 other states that are in the same position as Nebraska right now, where we're out of compliance with the NCAA law, or the settlement, I should say, the court finding. And they are going to need to pass bills just like us in order to be in compliance with it. And those states are also seeing bills like this coming through because universities want to be competitive. They don't want the best volleyball player, the best football player, whatever, saying, oh, Colorado passed their law and they're getting the settlement funds, so I'm going to go there. And it's just keeping us up to date and compliant with what the NCAA says, what the court have said, and with what it is that the universities want to do.
So this piece of legislation is stamped and approved by the university?
They are not taking a position on it, but we are still in conversation about it. They supported it in 2020. They aren't opposed. They aren't neutral. We're just working out. I think the ball's kind of in our court.
Okay.
Yeah, I think they are supportive, and I probably shouldn't say that on the record, but I'll say this: they've been a really, really positive partner in the process.
Okay, thank you.
Okay, thank you. Any further questions? Senator Hill?
Thank you. I was curious about why the addition of property on page 7. It's athlete's name, image, or likeness property rights. I don't know why the addition of property. Was there a specific reason why? I just don't know.
I think that this is an issue that came up in another state, and so it's another one of those things that's just covering bases to avoid having like an amendment or another bill next year or something like that.
Okay. And that's all I had.
That's
yeah,
a good
thank
question.
you. Yeah, thanks.
Any other questions? Okay, seeing none, thank
Thanks,
you for your
everyone.
testimony.
Appreciate it.